May it please the court. Brandon Orweiler for appellant Kevin Galassia. This case asks a straightforward question.
You're a little quiet. Can you move the microphone a little quiet, a little up?
Your Honor. How's this?
That's better, I think.
This case asks a straightforward question. When a foreign defendant takes financing from a California resident, hires California personnel to build its product, enlists California residents to market it, and sells it directly to California consumers, must it answer in California courts for claims relating to that business? This court's settled precedent holds yes. The district court reached the opposite conclusion by making two fundamental errors. First, the district court drew adverse evidentiary inferences against Mr. Galassia when the prima facie standard requires the opposite. Second, the court ignored this court's settled precedent on virtual contacts and fixated on the fact that defendants never physically entered California. On the first point, respondents' answering brief raises various factual disputes that are highlighted throughout the record, fixating on whether participated in a sale constitutes purchasing or selling. At record sites 51 and 52, and 56 and 57, Ms. Dieppe and Mr. Song, two purchasers of defendants' products, testified that they participated in both public and whitelist mint sales.
So why? I mean, so you those are among the contacts that you mentioned at the outset, but I'm having a little trouble understanding how the claim here arises out of or relates to those contacts. I mean, the contacts with the customers. Like, what does the claim have to do with the customers?
Well, if you look at Mr. Galassia's declaration, that's at record site 157, Your Honor. The key property at dispute here is ownership of the business. And one of the core claims that Mr. Galassia raises, which is another way the district court erred by fixating on only one set of claims, is a right to the royalties that are the proceeds of sales to California residents. Taking a step back on the blockchain, this royalty function is programmed into it such that sales to those California residents and secondary sales by those California residents would accrue royalties. All of the commerce in California, resales, everything related to it, is at stake and directly bears on the profit interest that my client has a right to. Ford v. Motor Company indicated that the arises from or relates to standard holds that it need not be directly causally related.
But do you think that would be sufficient? So if your client were like the defendant, also a resident of the UK, but everything else is the same, and you've got these business and California customers and all that, would there be personal jurisdiction in California?
I want to make sure I understand.
So everything about the case is the same except that your client lives in the UK rather than California.
And in this hypothetical, he's being sued by?
No, your client would be suing, but I think in the hypothetical, your client would be in the UK and the internet communications would have happened while he was in the UK, but for some reason he would try to sue in California over the ownership and royalty interests.
Yeah,
well, I think that would be under a different line of cases where we dealt with Asahi, where we have situations where we have complete foreign dependence. Like we have a foreign plaintiff and a foreign defendant on both sides of the question. And I think that's dealt with under a different line of cases that's not at issue here.
Well, I guess the point of the question was whether it is or isn't at issue here, because you just said all of these contacts with the California customers and the businesses in California and all of that is supports the exercise of personal jurisdiction. And so I was trying to get at whether you think that all of the stuff you had been saying was sufficient if you didn't also have the residency of the plaintiff being in California.
I think I get what Your Honor is saying. I'm not trying to dodge your question here, if I can answer it a little bit differently.
Well, I mean, I think the answer is either yes, that would be sufficient, or no, it wouldn't.
I would say no, just off the cuff. But I would say that the reason that doesn't matter here is what we're dealing with when we're looking at personal jurisdiction is always a sort of totality of all the contacts. And we have to look at everything and see whether we meet a threshold. And surgically extracting one of those is, I think, makes the hypothetical a little bit complicated. But I think that hypothetical, even if it turns out the other way, doesn't mean my client loses.
And do you think Briskin is your best case here?
Yes.
So I think you could use Briskin to support your answer to Judge Miller, I think, because Briskin is a lot about a client in California or a plaintiff in California with this internet conduct where the harm arises from the internet-related conduct where the injured person is in California, which I think is what you're trying to say is the same thing that happened here.
Yes, Your Honor.
There is a difference here, though, I think. So in Briskin, the injured plaintiff didn't even really know that Shopify was doing these things to his phone and his internet conduct. Whereas your client really affirmatively sought out this relationship with a business that was overseas and not in California. Do you think that matters?
I don't think that matters, Your Honor. And the way I would frame it is Mr. Galacio, as the record demonstrates, may have reached out first via Twitter. But taking a step back, the project was broadcasting itself on Twitter. And Mr. Galacio reached out, made contact after seeing it. And after their personal relationship had flourished over a few months, it was the defendant that first asked for a loan from Mr. Galacio after knowing he was in California and decided to create a continuous ongoing contract, which has been found sufficient since Burger King v. Rajevich.
So do you think that in Briskin, there was the plaintiff in California not really knowing even that any of these things were happening to him until later he found out there were cookies on his phone and these privacy violations he was alleging. Your client knew it was sort of a back and forth. It was a relationship between someone in California and someone overseas and a company overseas. So would the injury also have been in England? Or also in Hong Kong? I mean, is it in all the places or is it only in California? How do we think about where this happened?
Not knowing how English courts decide their personal jurisdiction rules and how that law applies. Sort of reversing it, I think with the nature of the relationship and it crossing these forums, it's a reality of modern commerce over the internet that if the shoe were on the other foot, it would have to be, bilateral. There's that continuing ongoing relationship from it. I think on the facts of this case, though, we don't need to go that far or even consider that because there were overwhelming California contacts that there weren't present in UK. If you were to balance it on a scale, there's one co-founder in the UK, there's one in California, but there's California employees, there's California marketing, there's overwhelming California sales that at the end of the day tip the scales towards jurisdiction. I'd like to reserve the remainder of my time for rebuttal unless there are further questions.
Judge Gould? Okay, thank you.
Good morning. May it please the court, Patrick Delahunty for appellees, Harris Bin Zafar and Project Ether Unlimited. Your Honors, the first point I'd like to make is that this case, I think as the court has pointed out, is a founder's dispute. It is brought by a California resident against a UK resident and a Hong Kong company doing business in the UK. The gravamen of the dispute is very simple, that the California resident loaned money to the company and has not been paid back the way that he wants to be paid back. It is not, by contrast, a case about the use of a website, consumer purchases. Those are not what this case is about or the action is brought on. And as a result, the controlling case and most on-point case is Pico versus Weston. It's very similar to the facts here. It is a case brought by a California resident against a Michigan resident. The California resident, they formed a joint venture. The Michigan resident would do all the work outside of the forum. The California resident, other than providing money, would also do some marketing and sales work in California. And this court found that that was not sufficient to hail the Michigan resident into California. It's squarely on point.
So we have Briskin, a recent en banc case that's really in this area of law that you didn't really address in your briefs. Can you address it now?
I can, thank you. I didn't address it. It was held or handed down. Well,
I think it was decided before your brief.
Okay. So let me address why it's not, I think, opposite. Because that case is brought by the user of a website. It is privacy claims. The allegation, I think some of the court's earlier questions acknowledge this, turned upon whether or not the use of the website affected these California users. There were cookies put on their phones. Their phones could be tracked by Shopify. Shopify was selling into California, had third-party relationships with other vendors in California. But it really turned upon the use of the website by the consumer and these digital artifacts being placed onto the California resident's phone. There's nothing like that here. This is not by a consumer. It's not by the user of the website. It's not about how the website affects commerce or individuals in California.
So why does that matter, though? I mean, the actual claim isn't really what the jurisdiction is about. So here we do have a California resident alleging that he was interacting by computer with your clients and was injured in California through those interactions. Why isn't that like Briskin?
Because it is impermissible under this court's holdings, starting with Axiom, to look only at the defendant's contacts with the plaintiff. It is the contacts with the forum. And there are not
Well, I mean, Walden says that, but in Walden, the conduct was outside of the forum. So when you're talking about contact with the individuals from the forum, when they're outside the forum, that is different than contact with the individuals from the forum in the forum. That becomes a contact in the forum. And that's what we have here, isn't it?
I don't believe there are any torts directed to anyone other than the plaintiff. And under Walden, it is the actions being directed into California. Here, the torts all occurred outside of California.
Well, how do we know that when there was there were communications between someone in California and someone in England or Hong Kong? How do we know that didn't happen in California?
The allegation is that the tort happened in a meeting in the UK. That there was
the ongoing sending of money happened from California, right?
That's the formation of the contract. That's a contract claim at purposeful availment. That's not the tort. The tort claims are different than the formation of the contract and where it was formed. And
the tort claims include a fraud claim, right? And part of the fraud claim is that the plaintiff was fraudulently induced to send this money, and he was sending the money from California, right?
But under Walden, it must be more than the defendant's contacts with the plaintiff.
But that's because those plaintiffs were in an airport outside of the forum. This plaintiff is in the forum when the contact happens.
That would always be the case if the suit is brought by a California resident, and it has to be beyond.
Well, not if the California resident is in Massachusetts when the problem happens. But if the California resident is in California when the problem happens, then the contact is in California.
I would ask the court to look at the Walden decision at 780 Federal 3rd 1206, where the holding is that there must be express aiming in the torts beyond the torts only connection to the state is the plaintiff's location.
Right, because in that case, those plaintiffs, when the incident that they're upset about happened, they were in an airport somewhere else. And then they tried to go home later and sue from home. But the conduct happened somewhere else. So the court says you can't use the fact that you're from somewhere to sue in that place when the problem happened somewhere else. But our problem in this case, allegedly anyway, was from someone in California while, at least a lot of it, while he was in California instead of while he was in an airport somewhere else.
That is the allegation. and I would submit that there has to be an effort to target California beyond the plaintiff's location here.
Well, so suppose suppose we have one of these people who claims to be a Nigerian prince, and sends the email asking for money, right? And he sits down and he thinks, well, a lot of people in Hollywood have a lot of money, so he gets like a list of studio executives, and he sends an email to one of them and says, I'm a Nigerian prince, send me money, and he stops after one email because that one is a success, and the person sends him some money. So he knew that the person was in California, and he chose them and sent them an email and got money from them. Can the victim of that fraud sue him? And suppose the sender lives in some foreign country. Can the victim of that fraud sue in California?
I would say under that hypothetical, yes, if the defendant knew that the victim was in California.
Well, isn't that basically the allegation we have here? I mean, the defendant knew before any money changed hands that the plaintiff was in California, and the allegations in the complaint are, it was a different kind of fraud, but the allegation in the complaint was that this was a fraudulent scheme to get the plaintiff to send money.
I'd say when looking at this case as a whole, and the purposeful availment and purposeful direction are not always sort of running on two separate tracks. There can be sort of conjoined analysis as to the reasonableness of hailing the defendants into court here. And if you look at the whole picture of that, it is the plaintiff seeking out the UK resident. It is the plaintiff forming a Hong Kong company that operates in the UK. It is that same plaintiff saying, I want all disputes about how we run this company. There is a founder's agreement. It's not executed, but it is probative of what they wanted. They did not want to be in California until all of a sudden it was beneficial. And that.
So the fact that it's not executed, though, is a real problem for you, I think, isn't it? Like, how do we use just a draft of something as evidence of intent?
I would think it would be dispositive. We wouldn't be here today if it was executed. But I think that doesn't mean it's not relevant. It was drafted. It was paid for by Mr. Galacio. It was not objected to. He said it was a good idea. He looked at 3 drafts with the same language. It's a fact this court considered and the lower court also considered. It does show the party's intent. Did they anticipate being hailed in the court here? Did they avail themselves of California? No, they did not. They sought to avoid California. That's why it would be unreasonable to hail them into court here. It is not consistent with fairness to bring them here when they were trying to avoid California.
Counsel, Judge Gould, if I could inject a question, please. Is the test for minimum contacts different for contract cases versus tort cases?
I believe this court recognizes that there are 2 tests for torts and contractual claims, but there are decisions within this court that acknowledge that they are not always separate. But the key difference in the contractual claims, Your Honor, would be the purposeful availment, looking at how the contract is formed, the intent of the contract, and the actions of the parties and the effects of the contract. Here, those are the points I just made, that this was a contract formed outside of California, that was not anticipating consequences here, that the behavior of the parties sought to avoid California on those claims. I would also submit that the district court did not err in finding that the defendants had met their burden to show that it was unreasonable to hail the defendants into court here. Those 7 factors all weigh heavily in favor of defendants here, some of which are not contested until the reply brief.
Can you, so there is, as you correctly say, the third part of the test about whether it would be unreasonable. But what is the best, are you aware of any cases where we said that, the first 2 prongs were satisfied and personal jurisdiction was not present because it failed prong 3?
Not off the top of my head, Your Honor.
My sense was that it happens very rarely, if at all.
That's my understanding too, Your Honor.
So what is it about, assuming, we would only get to this if we disagree with you on the first 2 prongs. So assuming that we disagree with you on the first two prongs for sake of this question. What is it about this case that's so extraordinary?
I think this case, thank you for the question. I think this case is extraordinary in the sense that there was an effort all the way through to be outside of California, and that each one of these factors, it kind of comes back to that. On the first factor, if this court does find purposeful availment or purposeful direction, I think it's a minimal finding. That's not enough under the first factor. There's got to be more than just minimal contacts. The burden on the defendant is large here. They did not want to be in California. They are in the UK. That's where the business is. That's the second factor. The third factor is that this is a foreign nation, not between two states, which does weigh more heavily in favor of the defendants. I think there's the fourth factor. This case is a little unusual as well. I think California has very little interest in adjudicating basically how a foreign company runs itself, particularly when this company was formed to avoid California.
Well, doesn't California have an interest in protecting its citizens from fraud, though, which is what the allegation is here?
I think those claims are not the gravamonte of this dispute. In this case, is really about the investment of money and whether or not it's been paid back.
So California probably has an interest in protecting its citizens from having contract violations too, right?
I think that would be true most of the time, but here this contract is about the formation of a foreign company, how it's doing business. And in forming it, these two people clearly indicated they did not want to be in California court. That's why it's different. I think if this court looks also at just efficiency, and I would say also in this case, I think it's important here that the plaintiff, until he filed suit, did not want to be in California courts. That's the difference. They were making, there's a really atypical, unusual effort to avoid California courts in this case, which makes it.
Sorry, so I know you have this draft agreement, but we're really at the motion to dismiss stage. Do we know anything about the drafting history really of that agreement? Like who wanted which clause and how it came to be?
There's no evidence of that in the record, but there is evidence that Mr. Galacio thought it was a good idea, that he did not. There's no evidence of him objecting to it. There are 3 drafts that all look the same. He acknowledges he paid for its drafting. They hired a Singapore-based company to draft it. That's all undisputed. It would be more efficient here, fifth factor, to have this case in England. I think that's pretty straightforward. And then 6 and 7, those 2 factors are a little unusual in this case. They were not challenged by Mr. Galacio in his opening brief. They're essentially waived, and there's almost no argument in the reply brief here. In the 7th factor, no argument at all by the plaintiff as to why other jurisdictions would not be suitable alternatives. These factors, I think this case is unusual in how heavily and consistently all 7 factors are in favor of the defendants.
Counsel, Judge Gould, if I could ask you a further question. The answer to this question is probably irrelevant if there is no jurisdiction. But does the record as it stands now give us any evidence about why the contract was not honored? The verbal, that is, why was the loan not repaid?
There is no evidence as to why it was not. I think at the time of filing it had not been repaid. There's no evidence that it had been repaid.
Okay, thank you.
Thank you, Your Honor. I would submit unless there are further questions from the panel.
Thank you.
Thank you.
I think we still had about 6 minutes for rebuttal.
My colleague, when he was up here, said the tort happened in a meeting in the UK and that it was a UK business. But that fundamentally misstates the nature of the business and ignores the reality of internet commerce. The tort did not happen in a meeting in the UK. The illegal recording that was mentioned happened in a meeting over the internet, where there was one party in California and another party in the UK recorded that in violation of California law. That's what is alleged. That's what the evidence shows in the record.
Could you speak to the 3 drafts of the unsigned contract?
Yes, Your Honor. My colleague made a point that I'd just like to address overall that the draft agreement was financed by my client. Everything was financed by my client. And none of that money was given back. The argument and the logic taken to its extreme with that point is that because my client was defrauded for financing the whole project, that we can point to an unsigned, unexecuted contract that he didn't agree to, didn't consent to, and has no weight, ignores this court's precedent and approaches absurdity.
It does seem that the parties contemplated Hong Kong, though, as where they would be interacting. What do we do with that?
Well, I think Your Honor hit the point earlier where there's no evidence of any drafting history in the record. If we're going to get into the weeds of that, there's nothing in this record, and this court's precedent at the prima facie stage would require inferences to be drawn in favor of my client on that point, not against him. This court got it right in Briskin, which is a case that my colleague has no answer to. He brought up Walden again, but footnote 9 of Walden expressly notes that that holding does not apply to virtual contacts cases. And it's a point this court got correct in Briskin, and it's a point this court should note here as well. My opponent also brought up the idea of needing something more to target California, not just a plaintiff, again evoking the idea of differential targeting, but that was squarely dispatched within Briskin. We don't need that here. The district court's relying on it below was not correct, and the court misapplied that law. Unless this court has any further questions, those are the points I would like to hit.
It looks like no, unless Judge Gould, do you have any questions?
No questions. Thank you.
Thank you both for the helpful arguments. This case is submitted.